All right, I guess I'll start. The sooner I start, the sooner I finish, and it'll be lunchtime. I want to start with 3 quick administrative notes. First is feel free to interrupt me with questions or comments or corrections at any time. I'm likely to say something that's irresponsible or downright wrong at any point in time, and so please feel free to either interrupt me or say a question until the end. Either's fine with me. Second note is for the people watching on the internet or that will watch it later on YouTube. That's just to say, one, I feel like I need to, for posterity's sake, explain away the informal attire, the t-shirt. It's going to be 96 degrees here in Denver today, so I left the nice, fancy, long-sleeve collared shirt on the hanger in the hotel. The other thing I want to say to the audience is this is likely the last time I will think about you or address you in the next hour. I apologize for that. And then the third thing I want to say to get started was I think I ran through probably 3 or 4 presentation themes and maybe a dozen or so titles in the course of submitting and putting this thing together. What was on the website even changed once or twice until I decided to stop bugging Elmer with my changes. The title, this is the title that appears on the schedule, or at least the shortened version of it. The title that I really kind of landed on last night was this one. As I talked to people during the day yesterday about what I was going to talk about, I realized that this was kind of the title that I needed to have, so here we are. This is a simple diagram for what I intend to talk about today. I hope most of the folks in the room, at least for the sake of argument, would grant that we at the LII could be considered legal tech. On the other hand, there's a lot of interest and discussion in talking about teaching legal tech, and so we've begun to think about what's in this purple space in the middle. What can we do that overlaps the space of teaching legal tech to help the students at our law school and perhaps beyond in a vocational prepare to practice sort of way. And I've been thinking about that quite a bit since, for a while now. A little bit about who we are. I think most people probably know about the LII. They've been to the website. When I tell lawyer friends this is where I work, they go, "Oh yeah, you people ask me for money all the time." So they definitely know who we are. Which are some of the stats that I throw out for people that aren't necessarily aware of the scope of our operation, including our own alumni usually. In the past 12 months, we've had almost 30 million unique visitors. They've engaged in over 47 million sessions on our website, viewing more than 115 million pages of content. And if you multiply out the number of sessions times the average session lengths, you see that they spent over 403 million minutes on our website, which is a lot. What do they look at in all those minutes and page views? Those are the top 5 collections, traffic-wise. Obviously, 4 of those 5 are primary law sources. The 5th being number 3, our 3rd most popular collection, which is WEX, which is secondary content. It is a largely student-created legal reference, encyclopedia/dictionary of content that's slowly evolving to be more expert-created, which is a source of another lecture for another day. As far as breakdowns of the usage, you can see there. U.S. Code and then CFR accounting for, in the aggregate, more than half of our traffic these days. CFR is definitely the fastest growing segment of that. There's just not a lot of other sources out there for regulatory stuff compared to, say, U.S. Code or case law or something like that. Lastly, who we are. We are 8 full-time employees, one of whom is an administrator, then 6 computer science folks, many of whom are in the room right now, and then 1 law-trained person, 1 JD with 2 working thumbs. And a lot of people that really surprises. They don't really understand that ratio. It's a law website, why they only have 1 lawyer and 6 computer science folks. Real quickly, this is a page from our site. Interestingly enough, it's the same page Tom Bruce used yesterday in one of his presentations. By sheer coincidence, this is Section 501 of the tax code. 501c3 is a phrase most people are familiar with. And here's the code. You'd be amazed at the number of people that I talk to that seem to be under the impression that we've got this room full of people that are looking at the law in a book somewhere and typing it onto our website. And obviously this room knows it's not really how it works. There's a lot more to it, just publishing the primary law from the original data sources. But we're also doing a lot more than that. Again, Tom stepped through a lot of this stuff yesterday, so I won't belabor these points. But for example, if you click on this tab right here, the IRS rulings, you see all of the IRS, what they call written determination letters that address Section 501 of the tax code. As far as we know, this is the only place anywhere on the internet, free or otherwise, where the content is presented this way. Even on the IRS's website, it's not presented. It's not organized around the laws which it's addressing. It's organized by date. It's organized by title. It's organized by these ponderous topic codes. It's not actually organized around the law. Another thing that we're doing is these related bills in Congress. This is any legislation pending that discusses or addresses the section of the law. So you click on one of these, it takes you right to the proposed legislation on congress.gov. And this is something that we're doing in concert with Cato Institute's Deep Bills project. You click on the Deep Bill, you click on that link, it takes you to Cato's Deep Bills page. You start to see talk about FDSys and XML and APIs and JSON, and oh my God, there's even code on this page. None of that, it meant nothing to me 2 years ago when I started LII. It's still not my bailiwick at all. Those folks are in the room if questions come up. But nevertheless, that begins to explain why we are a computer science heavy organization and not just a bunch of lawyers or law students sitting around copying code down and pasting it into a WordPress form or something like that. We do involve students. It's a very small core staff, as you can imagine, as I've shown you. And so, we do use a lot of students to help with various things. We use a number of computer and information science students at Cornell. Some of them are, a lot of them are master's level students, master's engineering students, masters of professional studies is an advanced information science degree that's offered at Cornell. And then even the occasional undergraduate wanders into our spaces, answering an ad, looking for help. And if you sat through any of Tom's stuff yesterday, or if you've talked to him, or even just the things that I've just shown in the last couple slides, those are all projects that to some degree or another we've had students assisting on, because we just don't have enough hands to go from, hey, it would be neat if we could do this, to an actual feature that we're able to put on our website. And so we've taken advantage of a lot of technically oriented, very highly competent, very in-demand labor kind of students to help us do some of those things. We also use law students, and that's really what I'm here to talk about today, is how we use law students. I want to real quickly show you a couple of examples of how we use law students. I'm not sure how well this is going to project, so let's see. It's going to be huge, as it turns out, easily readable. So this is our Supreme Court Bulletin, which is basically analogous to a law review or other academic journal in terms of size and organization. It's about 30 students, 24 second-year students who are the associates, the writers, and then we've got 6 third-year students who serve as editor-in-chief, executive editor, and managing editors. And what they do is they write a preview for each case that's going to be argued before the Supreme Court. And then we send these things out to our subscribers. We've got about 12,000 subscribers now who get these previews, and they also get the opinions from the Supreme Court as soon as they're made publicly available through their Hermes feed. This is our service is as fast, if not faster, than any other way to get the Supreme Court opinions when they come out. So they write these previews, and what I want you to see about these, they're all formatted the same: a plain language issue statement, a short executive summary, recitation of the key facts, analysis largely taken from the amicus briefs about the implications of the case, and then an analysis of the legal arguments that the parties are making as they sort of match up. Petitioner says, yes, we do. And respondent says, no, we don't. And these are their legal arguments for the sort of key points of the case. And the real thing I wanted I want to make sure I addressed about this is how these are put together. Students work in pairs. The second year students, the associates, write these things in pairs. They get their case, they read the materials, they read the briefs, they read the amicus briefs, then they get together and they decide which sections they're going to write. They go off and they write their sections, then they get together again and they synthesize the two parts of the work to make sure that it's a coherent, it appears as a coherent whole as far as stylistically, thematically, et cetera, and then it's handed over to a managing editor who manages and manages the process, edits the final piece, and then we publish these things. So like I said, it's analogous to a journal, but it's very different from a journal, and that folks are actually writing, they're not blue booking, and two, it's maybe a little different from a journal in that literally thousands of people are reading these things. And they get emails from folks that are involved or interested in the case. And
how long does it take to produce one?
So we try to publish 2 weeks prior to oral argument, so it's out on the internet, so people can pick it up if they're looking to learn about the case. And usually the schedule comes out probably 2 or 3 weeks before it's due. So you have like 3 weeks at the longest from the time they get it. It's a lot of reading, which is another reason why they work in teams. Because the person who's doing the legal analysis doesn't necessarily have to read all the amicus materials, and vice versa. The other thing, and to me that's sort of as a traditional use of law students as we do. So that's sort of a traditional model. You've got students researching and writing. The working together aspect isn't necessarily all that common for the law student experience, which we'll come back to. And then the other thing I wanted to show you was something that's a very decidedly non-traditional, typical way to use law students. This is something that we showed both on a little video that was running yesterday, and I think this came up at lunch yesterday too, the CFR definitions. So here's a section right out of CFR, 7 CFR 271.7, I just chose this one at random. And now all of the, in Title 7 and soon across the CFR, and soon across all the U.S. code, and I can say that because our technical director's on a plane right now, but very soon this will all be, everything will be like this in our site, in that all of the defined terms are hypertext. And so one, you realize that program is a defined term that means something in this section of CFR, and the user can click on it, and the user can see exactly what that definition is and where it comes from. So what do law students have to do with that? Well, they certainly did not write the software that extracted those terms automatically across the 95 million words of the CFR. But what they did do is they did provide some of the training data that the machine used to learn how to do this. They went through and they manually extracted definitions from certain parts of the CFR, and they handed it over to the team of Masters of Engineering students who were led by a former staff member of ours, Dr. Mohammed Al-Aswad, who's moved on. But Mohammed, working with the students, then taught the machine to do the work, and then I think the law students also played a role on the backside, doing some checking quality assurance as part of the training data set. And now Sylvia, who's in the room, Dr. Sylvia Kwakwe, who's essentially Mohammed's replacement, is nodding her head because this is now her nightmare. And, but I don't think you were around much when the law students, or you weren't around yet when the law students were doing their stuff sort of on the front side, which is why I attributed it to your predecessor. But yeah, again, she's certainly free to raise her hand and tell me I'm wrong if I've got that wrong too. But so that's the way that we use law students. It's definitely not sort of a typical run-of-the-mill thing that a law student shows up to law school to learn how to do.
I just want to correct any impression that any of you may have that being a semantic web person for the LII is a little bit like being the drummer in Spinal Tap. So it's probably saying.
So getting to legal tech a little bit, this is a definition that's solely of my own creation. And I noticed now never mind. And I started to put this talk together. One of the things that I realized from version 1 to whatever version this is that I've been very lucky to be able to travel to a lot of conferences where legal tech is the focus of the conference. And seen some people here that I've seen in some of those things. But I've been to enough of these that I thought, gee, one thing that would be a productive use of this time would be just to sort of distill down what's being said out there in the world about legal tech, whatever that means. So there's some of that in the coming slides. One of the things I noticed, and I'll be curious to hear if other people have had this same observation that have been to these things, they break down into two worlds. There's the business-to-business stuff, and there's the business-to-consumer stuff. And it seems to me, either from my own intuition or sometimes folks just come right out and say it, is that they set out to build something that's meant to be public-facing. And they say, I'm going to build an app that helps people file a Chapter 11 bankruptcy. And then at the end of the process, they say, hey, we built this great app that helps lawyers help their clients more quickly and cheaply file Chapter 11 bankruptcies. And I'm kind of wondering what the barriers are where they make that switch from building something that a person can use to something that a lawyer can use to help people. So I have my own ideas, but I'll just kind of leave that to the side for a second. And there definitely are out there some applications, some products and programs that are meant to be used directly by the general consuming public. LegalZoom I put up there is one that a lot of people are familiar with, or at least the concept of. Shake is this neat little, it's called Tiny Law. So they call it Tiny Law. So say you want to loan your roommate $400, or you want to buy or sell a washer and dryer on Craigslist, and you want to memorialize that transaction with a contract for whatever reason. Shake will help you do that in a way that's supposed to be very user-friendly to someone without any sort of legal training. SupportPay is a neat one, actually created by a frustrated lawyer whose frustration was dealing with, I think, her own ex-spouse with child support and custody issues, and she thought there has to be a better way, and the better way was to build this piece of software that helps people take whatever the court has ordered be done with custody and child support payments and manage it through the app, such that these folks who wish to have a very arm's length or farther relationship with each other can do it that way, and not be yelling at each other over the telephone, or having their lawyers call each other or whatever. So that's another just neat little quick anecdote about a consumer-facing app. So one question I have is, where does legal reference and legal research fit into this? And the reason I wonder is because that's really sort of some of the oldest legal technology that a lot of us are familiar with. Whether it's the LII or whether it's Westlaw or Lexis. These things have been around a while, and West and Lexis are an interesting example to me because a lot of folks wouldn't. I mean, those folks, as far as I know, well, I don't want to say they don't show up at the conferences, but they're certainly not front and center at the conferences. They're not there presenting, talking about all the neat things going on behind the curtain at Thomson Reuters. But then there's like a continuum when you start with West and Lexis on one end, and you go through like Fast Case and Case Text. And then Ravel's out there, and you get to that end of the continuum, and they're like, oh, that's definitely legal tech. And I'm glad to see you shaking your head. That's definitely legal tech. And so, well, why don't we really think of the big guys that way? And I think the reason I bring this up is because I think that there's a certain amount of that comes from the notion that legal tech as a term, in air quotes, is there's an element of disruption in it, right? And what you all and folks in this space are trying to disrupt is Westlaw and Lexis. And so if you say, well, that's the same thing, then that's sort of that idea is in tension with the idea of legal tech as a disruptive force. And so to me, that's an interesting thing that I haven't thought all the way through yet. But if you define technology as simply, as the dictionary does, as simply the application of science to create efficiencies, well then, yeah, obviously something like the LII or Westlaw, it is technology applied in the legal space. So, when it comes to that, are we legal tech? I'd like to think anybody know who this is?
Oliver. Good enough.
Good enough, right. This is Professor Oliver Goodenough. And I didn't just put this slide up here, for the sake of the pun. I put it up here because the next several slides are, let's say, inspired by his keynote talk that he gave at the last Stanford Future Law Conference at the end of April, which I was lucky enough to go to. And he said some things that, I don't know, maybe I'm the last person to have thought about these things, but I think the way he was received, maybe not. So I put this up here to make sure that I remember to give him credit for these ideas that I pretty much just kind of stolen from him. And so one thing that he impressed in his talk is really sort of almost a prefatory idea, was, you know, we think of legal tech and we think of disruption, and we think of all these old, ancient, this monolithic system of law practice that we're trying to tear down with legal technology. But the fact is, the system that's in place now is not a system that's existed since the beginning of time. You know, technology has already completely transformed American legal practice and legal training at least once before. And with that, I'll stop reading from my slides and I'll ask the question, how did this guy practice law? Anybody, 1846, anybody recognize that person? The people that were, as he comes into 1861, everybody recognizes him. I saw that picture, like, that's him, huh? But anyway, the question stands, how did Abraham Lincoln practice law in the 1840s before he was a politician? Most people in this room probably know. You know, he was an attorney in Illinois. You know, the attorneys and the judge would ride the circuit. I think it was the 8th Circuit in Illinois, and they would argue cases that were prepared for trial. And they certainly didn't drag around a covered wagon full of law books with them, right? The courtroom practice of law in the 1840s was essentially, you know, knowing the basics of the statutes and the basics of the common law, and then knowing the applicable aphorisms. You know, arguing how you know, equity abhors a forfeiture, or curitate consentire. Hey, at least I picked different examples than the ones that Oliver used. But that's what law practice was, and that's obviously not what law practice is, and that's not how we teach law students to practice law now. You know, every now and then there's some crusty old contracts professor that wants to tell you equity abhors a forfeiture, but by far that's not the general rule. And I took contract law from the crustiest and oldest of all contract law professors, so I can say that. So the question becomes, what changed? And the answer is, you know, one of the major changes is the steam-powered printing press, which was the first major innovation in printing since movable type. And now publishers could put out millions of pages in the span of time when they used to be able to produce thousands or even hundreds of pages. And that led to the mass production of books and manuscripts and newspapers, and these things became cheap and affordable and widely distributed. So that begins to start in the 1840s. And you know, what are the results of that? Anybody know who that is? Any of my Harvard folks here? That is Christopher Columbus Langdell. He takes over as the dean of Harvard Law School, sort of out of nowhere, in 1875, and he begins to completely tear down and rebuild what it means to train law students. Because now the law students don't just have to memorize aphorisms and understand the rules of the common law as provided. They can actually read the cases and extract the rules and then apply those rules to disparate sets of facts and argue over whether a case is more like, a new set of facts is more like this case or that case, which is the predominant model now, right? But in 1875, this was utterly revolutionary. Anybody know who this is? Another dead white guy. That is John B. West himself, Mr. West. Sorry, Tim. And his first set of reports comes out, and he starts in the Northwest reports, which I think the Northwest was like Illinois, in 1876. And here's a private collection of government documents, of court opinions, that's not being published by the government, it's being published by a private publisher. The idea being, there's so much of this coming so fast, we need a way to get it to the lawyers in a way that's organized that can help those people make sense of it. You know, really sort of the same sorts of things we talk about now, the proliferation of information that's out there. He was dealing with the proliferation of information. Now we talk about the proliferation of information from just the lawyers to everybody. And he was dealing with the proliferation of information from nobody to the lawyers. One more dead white guy. And I've given you the name here for those of you with good eyesight. Does anybody know what James Broadhead was doing before he was the United States Minister of Switzerland? He was the first president of the American Bar Association, 1878. So 1875 was Langdell, 1876 is West, 1878 is the American Bar Association. This stuff is all happening right around the same time. This is your sort of revolution 1.0, right? And why does the American Bar Association come into existence? Well, because now the skills that it takes to be a lawyer are very different. They're much more sort of academic, and they're much more, you know, professionalized than what was happening back 30 years ago in Abraham Lincoln's time. Abraham Lincoln, I learned in putting this together, to become a member of the Illinois bar in 1839 or 18 whatever it was. Anybody know what Abraham Lincoln had to do? He had to get a piece of paper signed by 2 justices of the Illinois Supreme Court avowing to his sound moral character. That was it. You know, no student loans, no bar exam, just an affidavit. But that's no longer of primary importance come 1878, or that's not the only factor anymore. There's all of this case law to learn and read and massage, and all of these books to get through, and all of this work to do, and so we need to professionalize the practice of law with the Bar Association, so that we don't have unqualified folks running around doing what it is lawyers do. Interesting to me in this context, because one thing that I've noticed is a lot of the academics who are sort of taking up the legal tech world from the academic setting, their prior expertise is in legal ethics. It's in the unauthorized, this is the unauthorized practice of law crowd. I'm thinking of folks like Renee Konenke at Michigan State, Tanina Ostain at Georgetown, who are now very visible folks in the academic world of legal tech. And even, I as a practicing attorney, and I probably should have said a minute, something about my background. Before coming to the LII 2 years ago, I practiced in an office in a big law firm, an AmLaw 100 size big law firm, for about 6 years. And when I sort of first came to this stuff, my first reaction to it was that very angle, the unauthorized practice of law. When do these apps start practicing law, and will the regulatory scheme support that, or will the regulatory scheme suppress that? And there was a fascinating panel at the Stanford conference that addressed that very issue, and it was very optimistic. Tanina Ostain's take at Georgetown, she's got students building apps largely in the sort of legal services space, and then of course with that, you can't talk about this at Cal without talking about A2J, right? And Tanina said something interesting to me. She said, as long as we're helping place Alaskan Native children in foster care, nobody's going to tell us that we're practicing law because no one's losing money. Again, just an interesting piece of the puzzle and all this stuff. So another thing we don't want to forget, a lot of folks when they sort of first come to the discussion of legal tech, they say, well, if we're going to do this legal tech, either the billable hours are going to have to go away, or we're not going to do it, lawyers just aren't going to do it at all. So sort of 2 observations on that end. I think the first one is also Oliver's, although I rewatched his lecture, I didn't hear him say it, so maybe it was something he said in a sidebar afterwards. But lawyers use email, lawyers use telephone. These are all technology. Lawyers use the internet for things, including legal research, and none of that has sort of completely torn down the structure, the business model. So maybe there's some hope that it's not an all or nothing, do or die proposition. And actually, now I think about it, it was actually Walters who was saying that, and it's Oliver who said the second point, which is, hey, look, lawyers are great at technology. We've had our own social network for 150 years. Martindale-Hubbell, when it came out in 1866, its stated goal was to ensure that any businessman, any business person, could find competent legal representation in any jurisdiction into which he might happen to wander. We had LinkedIn 150 years ago in Martindale-Hubbell. And we've had metadata for over 100 years. I mean, that's what head notes and key numbers are, right? I mean, they're metadata about what's in that case. And by no later than 1909, John West is writing about the problems of proliferation of cases and how are lawyers going to actually find what they need when there's so much case law out there. So he started putting metadata in his reports. So the idea that lawyers are all Luddites and they're all resistant to technology, trust me, I'm very sympathetic to that. I've certainly seen it plenty of times. I had a litigation partner when we told him that the client was producing another 14 terabytes of data that needed to be reviewed for the case. He asked me, how many banker's boxes is that? So I get the Luddite lawyer, right? I get that, but you know, at the same time, the opposite of that is there is hope, and it's not a one-size-fits-all thing. Now, so this is all old. Where we're at now, people seen this before? This is some, I see some yeses, some no. This is kind of big on the conference circuit now. You can see it's from a fairly recent article, ABA Law Practice Magazine. This is called the T-shaped lawyer. The idea is that new lawyers, in addition to having their deep legal training and expertise, also need to have this broad, you know, shallower skill set in things like discovery design and e-discovery, business tools and technology, what's the other there, project management and analytics, in order to be successful lawyers in the technology age. These are things that they have to bring to the table, and that's all well and good. And you know, half an hour into it, it kind of brings me to the core of the talk, which is we can all agree that these things are necessary. But the question is, how do you do it? Where do you find the time and the space in an already crowded curriculum to teach law students these other things? And who's going to teach it? You know, often the technologists who really understand and can break apart the technology in a way that's helpful and useful either are not lawyers, or have not practiced law, or have not practiced law recently enough that they can talk to the practical way these tools are being used. You find the folks that are actually using these tools out in the world who are practicing attorneys, and they may not have the credentials to come into a law school or the skill set to come into a law school and teach students. And how do you keep up? Because the technology is changing so fast, and a lot of these points are interrelated, right? In addition to sort of keeping up with the technology as it changes, who's to say what's the technology that ought to be taught? You've got, you know, are you trying to teach down very specific to very specific applications? Hey, here's Clio. Let's spend a week looking at the way people do practice management using software. Or, of course, you know, e-discovery is a favorite when people talk about legal tech. But that's not going to be relevant to everybody. Even at a place like Cornell, where I work, which places a very high percentage of graduates in the large law firms, there are still ample numbers of students that are going into government, that are going into you know, the public sector and other ways, that are going into, you know, a legal aid environment, public firms of public service, and the tools and the techniques that they need to be cognizant of and competent in are very different from what the folks that are going off to do doc review at large law firms need to be aware of. And on top of all that, there's a skills mismatch, right? I think there's another session going on right now. The title is something like, I was told there'd be no math. It's a data analytics session. But that's a very real thing among law students. The ability and interest and temperament of the folks that go on to get JDs are not always the same, to put it mildly, as the people that I meet that are the Masters in Engineering students and the MPS students that wander through our doorways. And so there's a skills mismatch, there's an interest mismatch. Something that I don't necessarily hear being addressed very much is, you know, I wasn't a law student that long ago. If somebody had said, you've just spent all this money to get a law degree, but that's not enough. You also have to master this other completely other thing that people go to school for years and years to learn how to do in order to get a job. That's a tough sell. Moreover, at a place like Cornell, I'm saying this on camera, at a place like Cornell, there's a certain, whether it's stated or whether it's merely just sort of assumed by the applicant pool, there's this notion that you come to the Ivy League, you come to the T14, and you'll be taken care of. You know, you can build your little bubble, and you graduate, and you'll pass the bar, don't worry, and you'll get a job, and everything will be set. You will be a special little flower. And so the idea that there are all these other chaotic things going on that you need to have some mastery over, or at least awareness of, is very sort of much in tension with some of the theming coming out of the admissions office, right? And so, you know, into that world, there are lots of shallows to navigate as you go through that. I didn't get a chance to test this. I don't know if it's going to work, so I'm not going to try to run it. I was actually going to show about 2 minutes of Oliver's talk at Stanford, because the last question he got was, okay, legal tech, this is great, what are the impediments? And his answer was, the largest impediment is the lawyers. He said he had just been to a meeting of the Palo Alto Bar Association, or whatever it's called, the lawyers group in Palo Alto. And he didn't say this, but I would think you would expect Palo Alto lawyers working in the Valley, having Valley clients, to be sort of on the bleeding edge of this stuff. And he said it was wholly disheartening for him because person after person would stand up in response to his talk and say, lawyers are different. What we do is different. Sure, you can use computers to diagnose diseases, or you can use computers to recognize, do facial recognition. But doing client problem recognition, that's somehow different and special. And what lawyers do, we are such special little flowers, right? That there's no way. And he doesn't see that entirely as a reaction, as a job security thing. I think I don't want to put words in his mouth, but I think he also sort of sees that as what's been sort of imbued in them from the time they signed up to take the LSAT, right? That this profession is somehow different and free of the chaotic forces of change. So, okay, so now some pictures of people who aren't dead. Anybody recognize this handsome man, international footballer turned telenovela star? No. Celia knows who this is. This is actually our dean. I just love that picture of him. So we're very lucky that for the last year, we got a new dean last year, Eduardo Peñalver, and Eduardo realizes how important this stuff is and that law schools need to be teaching it. He's also smart enough, sharp enough to realize that it's not easy for all the reasons I talked about and lots of others. And he wants us at the LII to help him figure it out, basically, to be part of the solution of how he's going to teach students at Cornell in this space, in this legal tech space. So thinking about all that, another conference I went to, everybody should know who this is. Yeah, everybody should, that's a rock star. This is Ed Walters, for those of you that don't know him. Ed is the CEO of Fastcase. If you ever have a chance, if you're ever at a conference where Ed's speaking, make sure you go to Ed's session, because Ed always is highly entertaining and also usually extremely perceptive. And he spoke at a conference at Georgia, a legal tech conference, future law conference at Georgetown back in April. He gave a very short talk. He was on a panel, and they each had like 10 minutes before the panel discussion to say their piece. He gave a very short, maybe 10-minute talk. And what he said was he talked about his high school art teacher. And what his high school art teacher used to say was, semper videns, always be looking. And he said when he got to law school, all he could think about was his high school art teacher. Every time somebody said, we're going to teach you to think like a lawyer. Because he said, yeah, and he's back at Georgetown as an adjunct now, and he said, every time I hear somebody talk about thinking like a lawyer, I have to stop and say to myself, don't stop thinking like whatever you were before you were a lawyer. Don't think like a lawyer at the exclusion of thinking like a librarian, or thinking like an architect, or thinking like a dancer, or thinking like a gamer, or thinking like whatever your identity was tied up in before you went to law school and you were told you were going to be this special little flower, right? And I thought about that, and I mentioned earlier on, actually I don't think I did mention earlier on, that before I went to law school, I was a naval officer, I was a tailor aviator. And any success that I had in law school and in practice, as I thought about what Ed said, I could really attribute to the fact that I never stopped thinking like a naval officer when I thought like a lawyer. And that sort of gave me a different perspective. It allowed me to try things or do things or experiment in ways that I always just attributed to being 10 years older than my classmates. But there was something to this. Don't stop thinking like whatever you were before you were a lawyer. So all these thoughts have been sort of percolating around in my head, what the dean's asking us to do, what Ed's saying, what Oliver's saying, my experience with these projects that I showcased earlier on, and I realized that for us anyway, that what's in here, in this purple space, is the ability to collaborate. And I went back and I reread the T-shaped lawyer, because a lot of you, you'll go to a conference and you'll see this, and people will say, we need to teach lawyers to code. See, the T-shaped lawyer is the lawyer who could code. I told this to a paralegal, and she said, I don't know any T-shaped lawyers, but I know a lot of pear-shaped lawyers. But if you read this, it's not an argument really in favor of teaching lawyers to code. What's in the T, what's in the narrow part of the T, is this notion of collaboration. And not just collaboration, but interdisciplinary collaboration. Teaching our law students who are going to be young lawyers that there are lots of things they can learn from sitting around a table with folks who are not lawyers. And nothing about their legal training has exempted them from the world and from the necessity, the increasing necessity, to collaborate, to sit down with the IT folks, or to sit down with the experts in their cases may have nothing to do with technology, the damages expert in a case of litigation, or whatever the situation may be. And Tom Bruce mentioned and put something on Twitter not too long ago that he was in a meeting where law faculty said in the new expansion that they're planning that there was absolutely no need for student collaborative space because law students don't collaborate, right? And I think there's a real chicken and an egg issue there. We don't expect them to collaborate. We don't give them the space or the tools to collaborate, so they don't collaborate. And then we say, see, we don't collaborate, so there's no reason to talk about collaboration because they're not doing it. So it becomes cyclical, when in fact it's probably, for us anyway, what we've identified as the way forward. And instead of trying to teach to a technology or to teach to an application or, heaven forbid, to teach lawyers to code sort of in bulk, just to teach them to collaborate, to be open, teach them just enough that they're open to the things that they can learn from the folks that come in to help them solve a problem that is outside of their depth, rather than thinking that somehow they have to figure this out on their own. And for the record, every lawyer that I ran into in 6 years of practice who did know how to code, they would be the first to tell you that they were barely treated like lawyers within their own law firms. They all ended up in, and I'm sure there are plenty of exceptions, but again, everyone that I ever knew who had any sort of degree, much less an advanced degree, in anything having to do with technology or computer science, computer security, they were all patent litigators. And what they did, I was a patent litigator too, but how we would be teamed is Nick and I, or Brian and I, would be on a case together, and he would make the claim charts, and he would do the invalidity contentions, and he would write the expert report, and I would be the one doing the lawyer stuff. I would be the one drafting the discovery and writing the meet and confer letters and keeping the client up to date and making sure that we were hitting all the deadlines and complying with all the local, and so we were both like half lawyers. So maybe teaching lawyers to code isn't necessarily going to do them a favor if we're going to send them out into the world and they're going to be told, oh, you know this stuff? We got a case that you can work on for the next 4 years. And we may not be doing them a great service in a lot of ways. So I had this slide up before, talked about these projects, and what I realized about these projects that made them sort of special and very successful for us is the collaborative nature of it. I made a point when I showed you the bulletin of talking about the way the students work with each other to put these things out. And for years, we've been in this time, what, maybe 15 years we started with the New York Court of Appeals? That's always been an internal marketing thing, both with the students and with the power structure in the law school, is the collaborative nature and how sort of unique that is. And then, of course, with the CFR thing, I talked about that too, and how the law students are providing feedback to the engineering students and to their supervisor in order to make the machine work better. And we said, well, so how do we go forward with that? How do we make these collaborative things happen more often and in a very sort of intentional way? So we're talking a lot now about how we can get the law students to work with the CIS students, whether it's a for credit relationship, or there's a seminar and we just give them a problem and say solve it. And they have this interdisciplinary team of IS and CS and law students that are solving, building a visualizer for this section of regulations, or any number of things. We can do, the training data example that I gave you before. We can do a lot more of that. If anybody sat through Tom's topic modeling talk and his several references to his hapless research assistant, Jonathan studied history at Duquesne before law school. I really don't think that he came to law school thinking he was going to be training a state-of-the-art machine to do, to automate unsupervised topic modeling and spit out, classify cases based on, based on basically a form of AI. That probably was not in his educational plan when he showed up at Cornell the first day. And I don't want to say if he can do it, anybody can do it, because that certainly belittles his expertise and his effort. But again, history major from Duquesne, not somebody that came to us with a systems engineering master's degree from Virginia Tech or anything of the sort. Another example of something, a very specific example of something we're going to take up, we have taken up, is something called VAST. VAST is brainchild of an immigration law professor and practicing immigration law attorney at Cornell named Steve Lord, and it stands for Visa Automated System Technology, his acronym, not ours. And so he came with us, and he said, what I want to do is I want to build an intake system so that when clients come to us with visa issues, that we can sort of very quickly figure out which bucket they belong in, and whether it's something we need to handle, or whether it's something we can sort of push down to somebody that works at a lower billing rate, or something that can be done in a different way altogether. We need to quickly assess how sophisticated and difficult and time-consuming this is going to be. Can we build something? And so we proposed two approaches to him. One is what I call the Iron Tech model. If anybody knows about the Iron Tech lawyer, we have some Georgetown folks here. Tanina Rastain at Georgetown has this program. And what they do is they have an academic license with Neota Logic, which is a piece of software, a decision, and their law students work in teams, and they build decision trees that go in the software. And this is exactly the kind of thing that they do. Veterans benefits. I mentioned earlier Alaskan, Alaskan children's issues, emergency services in Texas, on and on and on and on and on. This is exactly the kind of thing they do. But to our thinking, what they're doing is great, but to our thinking, we can go broader, because the Iron Tech lawyer is largely law students working with law students for a lawyer client to build an app that's presented to lawyers and judged by law professors, and it sort of lacks, and the actual tech of it is that black box of the Neota Logic. And so what we propose is we could do it that way. We could see if Tanina's interested in opening it up to other law schools and making it sort of the modern day college bowl, right? Or we can do it here at Cornell with an interdisciplinary team. It could be an example of one of these seminars where we put law students in a room with MN students or NPS students, and we say, here's a problem, build it from scratch. One of the shortcomings of using prepackaged software, if you're not doing it under an academic license, it's prohibitively expensive. If you're doing it under an academic license, what you can then do with the finished project becomes extremely limited because it's built into this academic license. And I can't give it to Steve Lord to go out and give to law firms to actually use as a tool, because that would exceed the scope of the license.
Sorry to interrupt you, but I've always wondered with that, because I know Tanina, why they don't use A2J often.
I know Neota. I don't
made any big approach to them about.
I don't want to speak for her, but I do know that Neota has always been a big champion of what they're doing, and I'm sure I would imagine there are deep loyalties there at this point.
Yeah, I understand that.
That said, I asked
that you wouldn't have to go through Tanina Rastain. You could do that
right.
with A2J author and scale that out. That kind of and start other law schools could.
Yeah.
Well, kind of dive into that.
So actually, Neota Logic and Georgetown have partnered on a business model. Yeah. And so the idea is actually to sell that to other schools. And so that's why the A2J thing, I think, is not contemplated, because it's a potential revenue source.
Gotcha. Fair enough. Yeah, yeah.
And I asked her because a particular project at the last Iron Tech caught my attention as something that we could actually, if it became a real product and not just this beta thing presented at this competition, that we could essentially advertise for on our site in the sound. I think it was veterans benefits. And we have literally millions of people that come to our site each year to read the regs and the laws on veterans benefits. And I said, rather than putting this on somewhere in some corner of the VA's website where people aren't going to find it through Google, they will if they Google the reg, they will find it on our site. And we could just send them straight there. And she this is when she made this issue of the academic license. Made me aware of it because she said, well, you know, they definitely want to use it in the real world, but we have these issues. And so I don't know the whole. It's not transparent to me what the whole relationship is.
Right.
Well, but I hear what you're saying, and that makes sense.
We're actually working with Neotologic on a different project. And so we've had lots of conversation with Michael Mills about what to do with law schools. And that's when he basically said, you know, what the Georgetown model is the way they're proceeding.
Yeah.
Because Neotologic is actually as much service as it is platform.
Right.
And he's also partnered with like Littler Mendelsohn.
Yeah.
They're rolling out a big platform for their clients based in Neotologic. So it's kind of all over the place.
Was anybody else at that Georgetown conference? Because there were two law firms that were there in Fort. Littler was one of them, and I'm totally blanking on. Seaforth Shaw was the other one. Yeah. Seaforth. They're just doing things other big law firms really aren't yet. But yeah, Neota. We're definitely. I mean, we're looking at doing stuff with Neota, but you know there are a whole set of obstacles and hurdles. And again, the other thing is now that we've what Tom calls the Newton doctrine. Now that we've focused in on this collaborative piece where we want engineering students in from step zero, building stuff from scratch. It's not always going to be the best approach for us to take something like Neotologic, which provides a certain amount of out-of-the-box, black box capability, and saying, here, lawyers, just use this, because that's not necessarily solving all of the problems that we're hoping to solve. You know, in the end, as we run out of time here, you know, we're trying to take law students from the special little flower to something more like this. So here's your special little flower, right? Still there. But now there are all these other different kinds of flowers, right? So that's it. So we can either have, you know, live discussion. Well, everybody knows what's coming next, right? So, you know, or we can go to lunch. And of course, Shaggy is the unofficial mascot of Cali 2015. I just thought the jokes were going to be fast and furious for 2 days, and I had to take a bunch of them out because I didn't want to be the only ones. But I left Shaggy again. So we can either eat, or you know, if people have questions or comments, we can talk some more. Sir?
I'm sort of curious about the social, cultural clashes when you put engineering students in a room with law students. Every time I've seen that happen, the law students sort of roll their eyes and go off in one corner and be extroverts to each other. And the engineering students go off in one corner and roll their eyes and stare at their laptops and be introverts. How do you have a facilitator in the room? Or
well, you know, what's interesting is part of that is about setting a tone early on. Part of that is about, you know, leadership on our part. Part of that, you know, we ran a project last semester. By we, I mean Sylvia and Sarah, who's on the plane right now, couldn't stick around after a presentation yesterday. She's been on the road for a long time. They ran a project of engineering students building a visualizer for the topic modeling stuff that we showed yesterday and I talked about briefly. And when I saw this presentation, the first question I asked was, because I was thinking about all this stuff, would it have benefited you to have a law student on the team? And one guy raised his hand and said, I've got a buddy who's a law student, and we just wore him out with questions. And so there may be a way to take sort of pre-existing social relationships to maybe overcome some of those hurdles, which is the case. There was this pre-existing friendship there. But you know, I'm more interested in chipping away at the law school anyway with this culture that's built up since the John B. West and C.C. Langdell days, that law students don't really work with other students. Just sort of, you know, every new law student has to be taught that. Really, that has to be inculcated into them in some way, shape, or form. And it's probably just through wandering the halls for a year without ever seeing anybody that wasn't a law student. At Cornell, the law school is at the very corner of the campus and sits right on the edge of the gorge. And Tom likes to say, you know, it's the dream of every tenured law school faculty to divert the gorge so that the law school is completely cut off. And so I'm very interested in that, and I'm interested in chipping away. We haven't really had that problem because most of the collaboration that we've done so far has been voluntary, I guess is the best word for it. You know, the law students that did the training data for the definition extractions in CFR, you know, they they were volunteers. It wasn't like, this is the class, you have to do these things. There were people that were actually working on other things. When Mohammed came to me and said, can you spare a couple of law students? I sort of pulled the group and said, anybody interested in this? A few of them raised their hands, said that sounds like fun. And they went off and did it and had a blast. So it's been kind of self-selecting so far. Tom, you want to say?
There's a bigger pool of examples we could draw on. I mean, we were just at an AI law conference in California where the guys have essentially the same problems that we do, which is getting just expert enough markup of data going into these systems to make the systems effective. So I met probably 3 or 4 people who were working with law students in that way at different institutions, and I'm sorry to say that I wasn't smart enough to ask them under what institutional rubric they were doing it. I mean, I know Vern Walker at Pitt is doing some of it under the umbrella of a health law program of some sort or other. I know there are at least 1 or 2 others out there. I'd be curious, I see Steve Bradford furrowing his brow, and the question that's floating over his head is, well, where's the pedagogical value in that? I'd love to hear what they had to say about it. We think that it causes them to look much more closely at the materials from which the data is drawn than they would in an ordinary classroom situation. And they do sometimes have the advantage of having to explain it to civilians. But again, I think there are burgeoning numbers of examples out there.
And we're not the only ones doing this. I actually, John Mayer, last hour, asked if you were starting a Cali from scratch, what sort of issues would it need to address? And I raised something that I've seen in the last several months. Is I go to these things, you hear about these great programs that are going. Like I learned about Blip at Brooklyn Law yesterday that I'd never heard of, and don't think I wasn't tempted to put a Jonathan Askin pun name slide in there too. I actually didn't take it back out. But you've got Blip, you've got Iron Tech Lawyer, you've got things going on. Was it Florida Coastal down in Jacksonville? What's his name?
Richard Granite.
Richard Granite, thank you. You've got stuff going on in Vermont where Oliver is. You've got stuff going on. I'm leaving lots of people out, but they're all sort of stovepiped. And you know, one thing that Cali or somebody else I hope will do is start getting the folks that are running these sorts of legal tech for law students things together, whether it's a best practices thing or whether it's something different or something bigger, to have that discussion. That's exactly the kind of thing you could discuss in that forum, is what are the best ways to sort of overcome those mismatches of temperament or perspective to get projects started smoothly and seen through.
I teach at Columbia Law School with Brian Donnelly and Conrad Johnson and so on, you know, in a clinic called Lawyering in the Digital Age. We do projects, and one interesting thing, in the law student body from about 10 years ago when their .com bubble burst, we have had a lot of people whose former lives, you know, think as you used to think, was in technology.
Yeah, that's what Jonathan was saying about.
And so they can pair with the law students who don't have the background, and they all have been poisoned by the legal background, and so they can talk to each other. And using open source platforms is really a great way to do. We've had students who did very sophisticated programming, but when they left, nobody could clean up the bugs. And so I really think that is a danger of the do-it-yourself programming by people who are experts, but transient.
Yeah, right, transient experts.
We've learned over the years that all student projects that involve coding, no matter what kind of students they are gifts to eat. We end up we'll get a finished project out of a dozen Masters of Engineering students, and it'll be, what? Wade's not here to tell me how wrong I am about this, but it's 2 months of somebody's staff time to clean it up if it's going into a production.
And so all the more reason why there needs to be a reason to do that project above and beyond the finished product, right? There has to be some institutional value add for the people that participated in it. Otherwise, you're just, like you said, you just received a puppy gift that eats, and you have to do so much work to do it. You start to question why you did it in the first place. So you can be very clear about what those other goals are outside of the finished product, right? We don't have that problem you mentioned at Cornell. We don't have a lot of folks in this day and age, or when I was a student, that come from really solid technical backgrounds. That's not the typical Cornell student profile.
But maybe the title of the clinic.
Maybe. But in some ways, I think it's nice because those students can be, you see that at Iron Tech, I think, sometimes. You can tell the one student in the presentation in the group of 3 that has a tech background because he or she does 85% of the talking, and the other 2 students do like the intro and the design stuff.
Oddly enough, the tech background people have more customer relations
Yeah.
than people.
Some of that's just having any work experience at all. So it's an interesting mix when you can get those students play a role, but also when they're absent, interesting things happen because sometimes the students that are history majors from UK have to step up. So it's lunchtime, unless I'm around. So.